Jurisdiction simpliciter versus forum nonconvenience. To understand the distinction as between jurisdiction simpliciter and forum nonconvenience, one will be well served to read the words of Supreme Court Justice Côté in the Supreme Court of Canada decision in Hearts.com versus Goldhar, where he succinctly and comprehensively analyzed and contrasted these two legal principles. Quote, "The jurisdiction simpliciter analysis is meant to ensure that a court has jurisdiction. This will be the case where a real and substantive connection exists between a chosen forum and the subject matter of the litigation. The forum nonconvenience analysis, on the other hand, is meant to guide courts in determining whether they should decline to exercise the jurisdiction in favor of a clearly more appropriate forum. The importance of maintaining the distinction flows from the discrete concerns underlying each analysis and the nature of the relevant factors at each stage. The real and substantive connection test at the jurisdiction simpliciter stage prioritizes order, stability, and predictability by relying on objective connecting factors for the assumption of jurisdiction. Conversely, the forum nonconvenience analysis emphasizes fairness and efficiency by adopting a case-by-case approach to identify whether an alternative jurisdiction may be clearly more appropriate. I will briefly elaborate on the principles underlying each analysis. In defining the content of the real and substantive connection test for the assumption of jurisdiction, the court was faced with a choice between an approach based on objective connecting factors and a case-by-case approach. This choice was characterized by the tension between predictability and consistency on the one hand, and fairness and efficiency on the other hand. Ultimately, the court decided to prioritize order and predictability at the jurisdiction simpliciter stage in the following terms. Given the nature of the relationships governed by private international law, the framework for the assumption of jurisdiction cannot be an unstable, ad hoc system made up on the fly on a case-by-case basis, however laudable the objective of individual fairness may be. As Justice LaForest wrote in Morgard, there must be order in the system, and it must permit the development of a just and fair approach to resolving conflicts. Justice and fairness are undoubtedly essential purposes of a sound system of private international law, but they cannot be attained without a system of principles and rules that ensure security and predictability in the law governing the assumption of jurisdiction by a court. Parties must be able to predict with reasonable confidence whether a court will assume jurisdiction in a case with an international or interprovincial aspect. To achieve this order and predictability, the court adopted to rely on a set of defined presumptive connecting factors as a jurisdiction simpliciter stage. This objectively ascertainable and relatively low bar to establishing that a certain forum has jurisdiction on a prima facie basis reflects the constitutional imperative underlying the jurisdiction simpliciter stage, as described in Van Breda. From a constitutional standpoint, the court has, by developing tests such as the real and substantial connection test, sought to limit the reach of provincial conflict rules or the assumption of jurisdiction by a province's courts. In its constitutional sense, it places limits on the reach of the jurisdiction of a province's courts and on the application of the provincial laws to interprovincial or international situations. The constitutional purpose of the jurisdiction simpliciter test is to establish a minimum threshold for the assumption of jurisdiction in order to prevent improper assumption of jurisdiction. Its objective is to delineate circumstances in which a court has jurisdiction, not circumstances in which it should exercise it which is the purpose of forum nonconvenience. The prioritization of order and predictability at the jurisdiction simpliciter stage is also consistent with the principle of comity, which is central to Canadian private international law. The prioritization of order and stability at the jurisdiction simpliciter stage, through the adoption of objective presumptive connecting factors, is meant to work in tandem with a flexible case-by-case approach to forum nonconvenience. Once it is established that a court has jurisdiction, the forum nonconvenience doctrine requires a court to determine whether it should exercise such jurisdiction. The purpose of the forum nonconvenience analysis is to temper any potential rigidity in the rules governing the assumption of jurisdiction and to assure fairness to the parties and the efficient resolution of the dispute. This is necessary given this court's recognition that jurisdiction may sometimes be established on a rather low threshold. By focusing on the context of individual cases, the forum nonconvenience stage plays an important role in striking a balance between order and fairness. Thank you.